What is a letter of administration of probate in Georgia? When a person dies without leaving a valid will in Georgia, the legal process of managing their estate is known as intestate administration. This process is overseen by the probate court, which appoints an administrator to manage and distribute the deceased's assets according to state law. The official document that grants this authority is called a letter of administration. This letter is essential for ensuring that the estate is handled properly, allowing the appointed administrator to collect assets, pay debts, and distribute the remaining estate to the rightful heirs. If you're dealing with the probate process in Georgia, it's important to understand how letters of administration work. Having the right legal guidance can help ensure that everything runs smoothly and that the estate is handled with care and legal compliance. Georgia law on letters of administration. Under Georgia law, the probate court is responsible for issuing the letter of administration when an individual dies without a valid will. The person appointed by the court, typically a close family member, is known as the administrator or personal representative. This individual is given the legal authority to manage all aspects of the estate, including gathering assets, paying debts, and distributing the remainder of the estate to heirs according to Georgia's intestate succession laws. The law firm representing you can assist in filing the necessary petition for letters of administration. Once the petition is filed and approved, the administrator is empowered to act on behalf of the estate. This legal authority is crucial in dealing with financial institutions, creditors, and other parties involved in the process. A lawyer's role is to ensure that the administrator's actions are legally binding and recognized by the court. In cases where there is no valid will, or the appointed executor cannot or does not wish to serve, the letter of administration is necessary to ensure that the estate is managed according to Georgia law. The attorney overseeing the process will ensure that the distribution of assets follows the legal order of inheritance, preventing disputes among heirs and delays in asset distribution. How to obtain a letter of administration in Georgia? The process to obtain a letter of administration in Georgia involves several steps. Filing a petition with the probate court. The process starts with submitting a formal petition for letters of administration to the probate court in the county where the deceased resided. This petition is typically filed by an interested party or heir who seeks to be appointed as the administrator. Along with the petition, a filing fee is paid to the court to cover administrative costs. Providing required documentation. The petitioner must provide all necessary documentation, such as the deceased's death certificate and proof of heirship, for the court to evaluate the petition. An heir determination worksheet may also be required to clarify the lineage and ensure all potential heirs are included. Notifying heirs and interested parties. All heirs and interested parties must be notified of the probate proceedings, either through direct communication or by publication in a local newspaper, as required by the court. This transparency is key to ensuring that all individuals with a potential interest in the estate are informed. Court hearing and approval. After reviewing the petition and resolving any objections, the probate judge issues the letter of administration. The appointed administrator may also be required to post a bond and take an oath of office. Additionally, the administrator is often tasked with filing an inventory of the estate and submitting annual returns to the court as part of the ongoing administration duties. These steps ensure that the estate is properly managed and that the administrator has the legal authority to carry out their duties. Difference between a letter of administration and a will. Understanding the distinction between a letter of administration and a will is essential when navigating the probate process in Georgia. A will. This is a legal document created by an individual during their lifetime, specifying how they wish their assets to be distributed after their death. It names an executor who is responsible for managing and distributing the estate according to the deceased's wishes. Letter of administration. This document is issued by the probate court when no valid will exists. The court appoints an administrator who manages the estate according to Georgia's intestate succession laws. The appointed administrator must follow state guidelines, rather than any personal wishes of the deceased. A will simplifies the probate process because it offers clear instructions for estate distribution. Without a will, the estate relies on the letter of administration, and the administrator must act within the legal framework set by the state, rather than personal directives from the deceased. For anyone facing the probate process in Georgia, understanding letters of administration and how they function is crucial. Whether you need help filing a petition, managing disputes among heirs, or navigating the complexities of estate administration, having an experienced lawyer on your side can make the process smoother and less stressful. The attorneys at Trace Brooks Law are committed to guiding you through every step of the probate process. Whether it's ensuring that the proper petitions are filed, or that disputes among heirs are handled efficiently, our team of probate attorneys in Atlanta is here to assist. For personalized legal guidance in estate administration, contact Trace Brooks Law today. Call us at 404-492-9559 and visit our office at 1275 Peachtree Street, Nebraska number 525, Atlanta, Georgia, 30309 for a consultation. Let us help you ensure that your loved one's estate is handled with the care and professionalism it deserves.